Okay, so let's just take a quick look now at involuntary intoxication. We've looked at voluntary, and I suppose a good starting point for us is to say what is involuntary intoxication. And I think the easiest way to state that is that the defendant does not know that they have taken either drink or drugs, and they do not know that they have become intoxicated. Now, that's interesting. The obvious way of looking at that is where we think about somebody whose drink is spiked, for instance. Somebody where a drug is put into somebody's drink and they become intoxicated without knowing. Or alternatively, somebody who is given what they consider to be a soft drink when actually it's an alcoholic drink. That classic notion of being spiked. Well, that's not the only way, however, because the defendant themselves could become involuntarily intoxicated by taking drink or drugs and not realising that the drink or drugs they take is likely to make them intoxicated. So the first thing is that there may be several different circumstances in which this is possible. For involuntary intoxication to be used, a defence must show that he was unable to form the mens rea. And the first thing about Kingston, of course, is what we've said all along, is that drunken intent is still an intent. Okay, so that's our first rule that Kingston gives us, and I will say that all of the time through these short videos. If you can form the mens rea, you do not have a defence. But Kingston went slightly further than that anyway. And Kingston, the facts of the case of Kingston's are quite complex and they're quite complicated. And it involves a man, Kingston, the defendant, who was sexually attracted to boys. He had not acted previously on that attraction, and at a stage went to the flat of another man, who we'll call X. Unknown to Kingston, the defendant, X intended to have Kingston, or lure Kingston, into a compromising situation in order to blackmail him. And to do that, he drugged Kingston's coffee. X then took the defendant into a bedroom where there was a 15-year-old boy who was also drugged. Kingston performed various sexual acts with the boy and was subsequently charged with indecent assault. Kingston claimed that he had no recollection of the assault as his drink had been laced with drugs by X, who had photographed the indecent assault. The judge said that involuntary intoxication is not a defence to a defendant who is proved to have the necessary criminal intent when he committed the offence, even if under the influence of drugs administered secretly to the accused by a third party. The trial judge had correctly directed the jury that if they were sure that despite the effect of any drugs, the defendant still intended to commit an indecent assault, the case against him was proved. Lord Mustell said that he was not even sure if a line could be definitively drawn between offences of specific and basic intent in this crime. So Kingston remains guilty. And it's that notion, it's a little bit like the Dutch courage case. If the jury is convinced that Kingston was likely or was able and knew that he was going to commit indecent assault even before he was drugged, then the case is proved and he cannot claim involuntary intoxication. The mens rea is almost formed before the intoxication. Now, it is worth reading Kingston, it's worth looking through it and reading it slowly because it's quite a complex judgment. But that is in effect the sort of nub of it. We then move on to this idea that where the defendant does not realise the strength of the alcohol or the drug that they've taken, and that's Alan. And if you remember, Alan was also guilty. And he was also guilty, we've looked at him previously, because intoxication remains voluntary even where the defendant claims he did not know the strength of the drink or drugs. If you remember, Alan drank some wine, the wine was stronger than anticipated, and he became drunk and tried to use that as an excuse. And the judge had said, it doesn't matter. If the drink is too strong for you, but you have taken the drink voluntarily, it remains voluntary. So Alan remains guilty. But what is interesting is to compare Alan with Hardy. Now in Hardy, it is a case surrounding Valium. And Valium is a sedative drug, okay? Also known as a soporific drug. And by sopor, I think I've spelled that wrong, soporific, that should be an I. A soporific drug. And a soporific drug is one that sends you to sleep. In Hardy, the defendant started a fire in a friend's flat after taking Valium not prescribed for him. Caldwell, the judge, distinguished because he did not have the mens rea and considered that whilst intoxication cannot usually be pleaded as a defence to offences of recklessness, the rule will not apply to drugs if the effect of a drug is merely soporific or sedative. The voluntary consumption of a dangerous drug might be conclusive proof of recklessness, but this is not the case with non-dangerous drugs, and a jury should have been directed to consider whether the defendant had been reckless in consuming the Valium, and Hardy remains not guilty. So what Hardy says is if you take, I suppose, dangerous drugs, illegal drugs, and you know that because you know that they are bad for you, you do not have a defence. But if you take Valium, even if it's prescribed for somebody else, because we all know that Valium is supposed to send you to sleep, it's supposed to be a sedative, it is not a dangerous drug in itself, if it has a reaction that causes you to do something that you would not expect to do, you may very well be able to have an involuntary intoxication defence. And that's why Hardy is found not guilty. So I've given you three short scenarios to think about. The Kingston-Allen sort of guilty scenarios, and then the Hardy not guilty scenario. And just balance those when you're talking about that in problem questions. Just think about, can I apply Hardy or Allen to this particular case in terms of involuntary intoxication?